6 types of debts seniors should never pay, legal limits and financial protections. 1. Medical bills already covered by Medicare or insurance. Duplicate billing is among the most common forms of financial exploitation faced by seniors. After Medicare or supplemental insurance discharges an obligation, providers sometimes send follow-up statements suggesting additional balances are owed. This practice, whether intentional or inadvertent, creates panic and induces unnecessary payments. Federal law provides that once Medicare or an insurer has satisfied its portion, the patient has no further liability for the same charges. Verification with Medicare or the insurer is the proper legal safeguard before payment is made. Failure to verify results in improper depletion of retirement income and unnecessary distress. Footnote: Federal law precludes double liability once Medicare or a supplemental insurer has paid. 2. Old debts beyond the statute of limitations. Every jurisdiction establishes a statute of limitations that bars enforcement of consumer debts after a defined period. Once this statutory time expires, the debt remains as a historical record but cannot be judicially enforced. Unscrupulous collection agencies target seniors by reviving expired obligations through letters and phone calls, hoping ignorance of the law will induce voluntary payment. Legally, such payments are gratuitous and not required. Enforcement is time-barred, and payment may revive otherwise dead obligations. Seniors must assert their statutory rights and refuse collection attempts once the limitation has lapsed. Footnote: Expired debts are unenforceable in court under state statutes of limitations. 3. Debts owed solely by a deceased spouse or family member. Creditors often misrepresent liability following the death of a debtor by contacting widows, widowers, or children. The estate of the deceased may be liable, but surviving relatives are not personally responsible unless their name appears on the contract or they co-sign the obligation. Demands made against survivors outside of probate proceedings are legally void. Payment under emotional duress depletes essential retirement resources and constitutes a form of predatory collection. Knowledge of the principle that debts die with the debtor, except as enforceable against the estate, is indispensable. Footnote: Absent co-signature, survivors are not personally liable for debts of the deceased. 4. Unauthorized charges and billing errors. Consumer law recognizes that billing errors and unauthorized charges do not create legal liability until resolved. Credit card issuers, hospitals, and utilities must remove or investigate disputed entries under federal and state statutes. Seniors frequently overlook small recurring charges that accumulate into substantial losses. Challenging such charges, whether subscription fees or duplicate entries, preserves financial integrity. Vigilant review of statements is not only prudent practice but also an act of legal self-defense. Errors cannot be enforced as valid debts. Footnote: Federal law obligates creditors to investigate disputed charges and bars collection until resolved. 5. Debts discharged through bankruptcy. Bankruptcy law grants a fresh start by extinguishing qualifying debts upon discharge. Yet collection agencies continue to solicit payments, exploiting fear of legal consequences. Payments made post-discharge are voluntary and non-obligatory. Once a court issues a discharge order, creditors are permanently barred from collection under penalty of contempt. Seniors who continue to pay discharged debts waste scarce resources and undermine the purpose of bankruptcy protection. Legal literacy in this area restores dignity and protects against continued exploitation. Footnote: Debts discharged in bankruptcy are extinguished and permanently uncollectible. 6. Debts belonging to adult children. Intergenerational financial pressure is one of the most emotionally complex burdens seniors face. Adult children's debts, credit cards, loans, or medical bills, cannot be imposed on parents absent co-signature. Collection efforts directed at seniors for their children's liabilities are improper and unenforceable. While familial loyalty often induces voluntary payment, the legal system imposes no such obligation. Seniors must preserve their assets for their own health and welfare, recognizing that financial independence is essential to dignity and survival. Allowing children to bear their own contractual burdens is not neglect but responsible stewardship. Footnote: absent co-signature, parents are not liable for adult children's debts.